quick check if you'd like, just for
Okay.
your own.
Hello. And so can I take it off and walk around then?
Should
Yeah?
be okay for that.
Okay.
Yep.
Okay, yeah, that's all right then. Yep.
Okay, well, good afternoon. My speaking notes say that my name is Professor Sarah Birmingham, but that's not correct. My name is Dwight Newman, and I'm pleased to welcome you to the second lecture of the 2025-2026 academic year at the College of Law. Professor Birmingham very much wanted to do the introduction, but has a sick child and so isn't here. But I know that she's very much valued Professor Frock's mentorship through the year as our visiting chair. We've all valued Professor Frock's presence, and she's brought a lot to the College of Law. There are two preliminaries, and then I'll turn to introduce her. So first of all, on a very serious matter, as we gather here today, the University of Saskatchewan acknowledges that its main campus, including the College of Law, is on Treaty 6 territory in the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationships with one another. There are obviously always many important issues to reflect on in terms of Canada's relationships with Indigenous peoples, very serious matters, and worth especially reflecting on every day, but especially this week as we have Truth and Reconciliation Day nationally tomorrow. On a less serious and more fun matter, if you didn't get a chance to enter yet, there's a door prize to my left, and we'll leave it out at the end of the event so that you can enter for the door prize, just as a extra thanks for attending. And it's great to have so many of you here. And we also know that there are many people attending online. Our guest speaker today is Dr. Kerry Frock, who's the Law Foundation of Saskatchewan H. Robert Arscott Chair here at the College of Law this calendar year. This chair was established in 1989 under an agreement between the Law Foundation of Saskatchewan and the University of Saskatchewan. The chair was renamed the Law Foundation of Saskatchewan H. Robert Arscott Chair in 2014 in honor of Bob Arscott, FCA, who served as Secretary of the Law Foundation of Saskatchewan from 1973 until his retirement in 2013. The wide terms of reference for this chair accommodate appointments in any area of law or in law and policy. So those who've held it have been accomplished legal scholars and other outstanding persons with a background in law and a demonstrated interest in scholarly investigation and practice relating to issues in law and policy. And it's been upheld very well with our latest chair, who's brought all of that and more. Although holders of the chair have limited teaching duties, they also engage in research and other scholarly activities, such as conferences and special seminars related to the chair. And I'll just advertise briefly that Professor Frock has a conference upcoming on October the 24th on multidimensional equality. And this is in connection with the 40th anniversary of the coming into force of Section 15 of the Charter, the equality rights provision in the Charter. If you're interested in this conference, please look on the College of Law website, and there are instructions there already in place on how to register for that conference. Kerry Frock is an associate professor at the University of New Brunswick Law Faculty, as well as a Trudeau and Vanier scholar. She's taught courses at Carleton, Queen's University, and the University of Ottawa on feminist legal theory and various aspects of public law, amongst other areas. She received her PhD from Queen's University in 2016 and holds a Master's of Laws from the University of Ottawa, a Bachelor of Laws from Osgoode Hall Law School, and a Bachelor of Arts from the University of Regina. Before completing her doctorate, she spent 18 years as a lawyer, as a civil litigator in Regina, as a staff lawyer for the Women's Legal Education and Action Fund, or LEAF, and as a staff lawyer in the areas of law reform and equality at the Canadian Bar Association. She's a member of the Saskatchewan and New Brunswick bars, and we've been very lucky to have her come home to Saskatchewan during this year and to get to hear her lecture today. So please join me in welcoming Professor Kerry Frock.
Well, good afternoon, everyone, and thanks for that kind introduction, Dwight, that you were pinch hitting and doing, so thank you very much for that. And it's very nice to be back in Treaty 6 territory. I see a lot of people wearing orange shirts, which is very appreciative of, and marks the solemn day tomorrow. I myself teach in the unceded, unsurrendered territory of the Wolastoqey, who together with the Mi'kmaq and the Pescomotati tribes signed peace and friendship treaties with the British Crown in the 1700s, so a much different indigenous legal orders from whence I come. So, putting my clock on here. And I really did want to thank very much the College of Law and the Law Foundation of Saskatchewan for allowing me to be here today and indeed funding my chair. It's been a real pleasure to get to know my colleagues here and to continue my work. While here, some of what I've been up to is acting as co-counsel for 2 interventions at the Supreme Court of Canada representing the intervener, the National Association of Women in the Law. And I've also conducted research on women's rights in constitutional cases concerning violence against women. But personally, and as important to me, it's allowed me to come home. I kind of feel like a little salmon coming back to the spawning grounds because indeed I was born across the street at the Royal University Hospital, and my mom and dad are here today, Jean and Myra Frock, so it's very nice to have them here today too. I think they haven't heard me speak since I was in grade school, and I used to participate in speech contests. So hopefully I've improved a little bit since then. They can tell you whether or not that's true, I suppose. So what I wanted to start with today is something a little bit unexpected. Billie Eilish. She has a song called Male Fantasy. And on the surface, the song is, a typical pop song about heartbreak. But underneath, it's really about disillusionment, about realizing that the world that you've been living in isn't really built for you. It reflects someone else's reality. It's a world scripted mostly by men about what life is about and what it should be. And that's why the fantasy feels so real. It's not an accident. It's a construction. And when you're inside it, it's hard to see it for what it is. And our constitutional law has its own version of male fantasy, the story that we tell about the notwithstanding clause. Section 33 is sold as the height of democracy. It's how we in Canada say that we reconcile majority rule, our self-government, with the protection of individual rights by unelected judges. And lawyers even have a name for this crisis of democratic legitimacy. It's called the counter-majoritarian dilemma. And the idea of how the notwithstanding clause solves this dilemma goes something like this. Judges are human beings, they get things wrong. Sometimes legislatures want to protect non-charter interests, and sometimes provinces want to promote their own distinctive cultures. And in that case, the people, through their elected representatives, the legislatures, have the last word. And that's through the notwithstanding clause, and they can invoke it at least with respect to certain rights. But that story is a fantasy. One aspect of this fantasy is that legislatures act as proxies for us and carry out our vision of the public good. Yet women and minority groups remain chronically underrepresented. And meaningful public consultations on important laws are often limited, or like the recent Saskatchewan Parents' Bill of Rights, are non-existent. Another illusion is that voters' preferences straightforwardly reflect their interests, but increasingly we see how misinformation and disinformation and algorithmic targeting shapes how voters see their interests. Has to be my mom, right? So the way that this algorithmic targeting works is that it often persuades people to see their interests as aligned with dominant groups. And as Tracy Higgins reminds us in an article called Feminism and Democracy, if the legitimacy of our system of constitutional democracy depends on the people having the final say, it already fails on its own terms. The masculine lens of this counter-majoritarian dilemma fails to engage with many important concerns of women. And like the song Male Fantasy, it describes a reality that reflects those who hold power, not those who are living under it. And yet, sometimes the state isn't even the main source of women's subordination. Public power sometimes is necessary to enhance women's equality in ways that the courts may overlook. And we saw this in the Brown and Sullivan cases where the Supreme Court struck down limits on the extreme intoxication defense. And the effect was to permit mostly men to argue that their own voluntary intoxication excused violent crimes, often against women. In response, some called on Parliament to use Section 33 to reinstate those strong limits, including Sarah Birmingham, who isn't with us today. This is where Section 28 of the Charter matters. It provides the Charter with what Higgins calls a feminist theory of trustworthy democracy, and it mitigates the flaws behind this gendered version of the dilemma. Now, Section 28, and you'll see the text in a minute, explicitly guarantees that all charter rights are afforded equally to men and women, notwithstanding anything in the charter, and that includes the notwithstanding clause. Its objective is clear. Both states and courts must respect women's entitlement to equal rights. And it directs courts not to treat women's rights as second class, and legislatures not to legislate as if they are inferior. Use of the notwithstanding clause is more democratically legitimate when women are equal partners in civil society. But here's the thing. Seen through a masculine lens, Section 28 becomes the problem. It threatens this made in Canada solution to the counter-majoritarian dilemma. And so yet we get another male fantasy, that the notwithstanding clause is all-powerful, limitless, and it's ridiculous to think that a gender equality clause like Section 28 could possibly constrain it. So before I dive any deeper, here's the roadmap for what I'm going to talk to you about today. First of all, what Section 28 is, how it relates to Section 33, and why their interaction matters. The second part is the myths around the notwithstanding clause and how they are gendered. The third is how Section 28 acts as a guardrail and limits the scope of the notwithstanding clause. And finally, I'll conclude with talking about what this all means for women's rights and democracy in Canada. So first, let's get to Section 28, and here's the text. I'll stand aside so you can read it if you want. I know it by heart by now. Notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. So Section 28 was added at women's insistence. And the reason they did that is because they were skeptical that Section 15, the General Equality Clause, would be strong enough to secure genuine equality for women. What we had before, the Canadian Bill of Rights, wasn't really up to the challenge, and the initial draft of Section 15 reproduced much of that problematic Canadian Bill of Rights language. They were also wary about other charter provisions undermining women's rights. For instance, the draft of Section 1, for all you first-year students, you know that by now, it's the justification clause. And women then called it the Mack Truck Clause because it would run over everyone's rights. And the initial draft seemed to let governments justify discrimination if it was generally accepted by democratically elected legislatures. And what that would likely mean is that collective interests, as decided by the majority, would always trump individual rights. And so Section 1 was only partially revised in response to the concerns of women and other groups. And so feminists pushed for a stronger guarantee, one that would apply notwithstanding anything. It was their insurance against things really going completely off the rails and their rights being crushed. So then we have Section 33, and I'll only reproduce the first part. That's what we call the notwithstanding clause. It essentially says that Parliament or a legislature or province can expressly declare that a law shall operate notwithstanding Sections 2 and 7 to 15. So what are these rights? Section 2 are our fundamental freedoms, things like freedom of expression, freedom of religion. 7 to 15 includes fundamental rights like life, liberty, security of the person. A lot of people are surprised that you can abridge the right to life using the notwithstanding clause, for instance. And it includes Section 15, the general equality clause. And Section 33 came around about 6 months after Section 28 was added to the charter, the draft charter. And it was what was called part of the Kitchen Accord. So a number of provincial representatives and Jean Chrétien, they all huddled in a kitchen in the Ottawa Conference Centre, and they hammered out an agreement that would allow the provinces to come to substantial agreement and allow our charter and our constitution to be patriated. So while the draft that these men created of the notwithstanding clause didn't initially include Section 28, it quickly became clear that the provinces wanted to pull it into the override. So what happened is they proposed a number of amendments to Section 28 and 33. So the draft that was proposed said that laws could operate notwithstanding Section 28, and what Section 28 said is notwithstanding anything except Section 33. So women were absolutely furious. They felt that this was a betrayal, and they mobilized quickly. They saw it as a clear indication that governments wanted the power to treat women and men differently and women as inferior. So Trudeau, the elder, Pierre Trudeau, said to his Minister for the Status of Women, Judy Arola, well, if you want this changed, what you're going to have to do is get the unanimous agreement of all the provinces to change it back to its original wording. And they got it. Here in Saskatchewan, Alan Blakeney was one of the last holdouts, but eventually, after a frozen protest in November in front of the legislative buildings, he relented. So Section 28 stayed free of Section 33. So the exclusion from notwithstanding anything for 33 doesn't exist. Women insisted on that, and they won. And that history matters. Treating Section 28 as so marginal that it couldn't possibly protect women's rights from the notwithstanding clause ignores this history and rewrites the deal that was struck in 1981. And the ordinary meaning of notwithstanding anything simply confirms the terms of this deal. In the words of Minister Arola at the time, she said on the radio, when we say no discrimination on the basis of sex, we mean never. So that's the story of how women's equal rights guarantee remained free of Section 33, not by accident, but because women insisted. But notice what happened to the way that the patriation history has typically been told. The inclusion of Section 33 is remembered as a decisive, in fact, even heroic, move by the premiers and the feds. It saved the charter. We didn't know if we would be able to patriate it. We didn't know whether we'd be able to get agreement. We proposed the notwithstanding clause, and that's what broke the deadlock. And they provided this principled solution to the impasse, and that's why we got the charter in our constitution. Just out of curiosity, how many of you have heard about Section 28 before coming here today? Okay, lots of people, that's good. My work, my work is partially done, I guess. So, but if you ask even the average lawyer, a lot of them haven't even heard of Section 28. So that fight isn't often remembered at all. And when it is, it's seen as women irrationally insisting on something that's irrelevant, confusing, or merely symbolic. And that contrast is not neutral. It reflects deeper patterns in how law codes traits associated with masculinity as high value and others associated with femininity as low value. And this is what I mean when I say that the mythology around Section 33 is gendered. And when I use the term gendered, I don't mean just about women, and I don't mean overt sexism. What I'm relying upon is, I read a book by Joanna Conahan called Law and Gender. And there she said that law can help reproduce gendered dynamics of power, not just reflect them. So consider how our legal system ascribes higher value to the following traits: reason, abstraction, neutrality, the public sphere, and lower value to these: subjectivity, context, particularity, the private sphere. And so these codes map onto masculinity and femininity, respectively. But they also map onto the origin stories of Section 33 and 28, and indeed the provisions themselves. And the stories we tell about these provisions, one created by men for use by male-dominated governments, and one created by women for women, have resonance because they feel familiar. And the gendered stories we tell about these provisions drive the outcomes. They, in fact, have material consequences and have had material consequences. So I want to highlight 3 of these myths. First myth. Section 33 is described as parliaments and legislatures having the absolute unfettered discretion to invoke it. It means that the legislative branch has the last word. Section 33 is straightforward. All you have to do as a legislature is expressly declare that you want a law to operate, notwithstanding sections 2 and 7 to 15. It has a 5-year sunset, and then you can reenact it if you want. Versus how Section 28 is described. One person said it's immensely complicated. It's queer, believe it or not. Controversial. It just provides emphasis to Section 15, the General Equality Clause. Professor Hogg, who's the god of constitutional law, sorry, Dwight, said it's unclear what real work it has to do. There's a lot of fear-mongering about its negative impact on affirmative action programs, that it would mean extending the charter to private actors. Why it's gendered? This myth, this story, codes Section 33's notwithstanding as decisive, clear, and rules-based. Section 28's notwithstanding is construed as borderless, vague, and context-based. Section 33 has the Supreme Court of Canada's decision in Ford that courts should keep their hands off, except to ensure that legislatures are using the right form. Section 28 gets mired in critics' technical interpretive arguments based on grammar, what guaranteed means, which always kind of reminds me of Bill Clinton's depends on what is, and odd arguments based on the chronology of charter drafts. And what the real story is that Section 33 isn't absolute. It has limits to its scope. The limits are the rights that are indicated, and there's lots of ambiguities that still remain. Can a court make a declaration on what rights are violated, even when the notwithstanding clause is invoked? What about claims based on constitutional architecture or unwritten principles? And Section 28's language is at least as plain as Section 33's. On a straight reading of notwithstanding anything, if the operation of Section 33 produces unequal enjoyment of a listed right, for instance, the ability to practice one's religion, as we'll talk about with Quebec's Bill 21, Section 28 limits the notwithstanding clause. No matter what you can do as a legislature, the one thing you can't do is make a law and protect it by the notwithstanding clause that results in women having unequal rights. And indeed, the Supreme Court of Canada, in a recent decision, points the same way. It recognizes equal rights in Section 28 as a hard limit on what they call charter shields, things that shield laws from charter challenge. So the bottom line is, if Section 33 is Confederation's safety valve, Section 28 has to be the guardrail, and courts ought to favor plain meanings of text, not technical wizardry. So the second myth is one about legitimacy. Section 33 is presented as embodying principled balancing, a dialogue between the branches, mitigating the counter-majoritarian problem, which you now know what that means. And Section 28 is described as literally an unfortunate result of enthusiastic lobbying by women's groups. It's unprincipled. Interpreting anything to mean anything is absurd. It would disregard the very structure of the Charter because it suggests that rights aren't subject to reasonable limits. And why is this myth gendered? It casts men's bargains struck in a kitchen as the work of a as constitutional geniuses, and women's insistence on equality as an irrational overreach. It's just a trick of lobbying. The interpretation of 33 as imposing requirements of form only is portrayed as, well, that just is what the text says, as an abstract and neutral interpretation, whereas interpreting anything to mean anything in 28 is a clever workaround. And again, it's 100% is a dog whistle for these old tropes. Deliberate and methodical men and their abstract interpretations versus rash, manipulative women and their overwrought interpretations. What the real story is? The story of Section 33 as principled imagines judges and legislatures dialoguing and politely correcting one another, but look how it's actually been used. Preemptive use, so use of the notwithstanding clause before a judge even sets a toe in to look at the constitutional validity of a law. Preemptive use has become the norm, as in Bill 21's law, which is the banning of religious symbols by certain government workers, and Ontario's Bill 28 that was used against educational workers. So this isn't a dialogue, this is a single majoritarian voice. The Supreme Court of Canada sanctioned preemptive use, so that's one of the things that the court said in the Ford decision in 1988, that you can use the notwithstanding clause preemptively, but you'll search in vain in the text of the notwithstanding clause. There's nothing in the text that authorizes it, and indeed none of the framers really anticipated that use. And recent uses have been driven less by rational deliberation and more by fear or bias, such as Muslims in Bill 21 and trans students in the Saskatchewan Parents' Bill of Rights. And when you look at Section 28, and I just wanted to give a little example from the Globe and Mail on how limits are described on the notwithstanding clause, using end runs around the Charter. So as I tell my students, I'm not just making this stuff up, it actually exists in the real world. But if you look at Section 28 wasn't made up out of whole cloth. It was derived from equal rights guarantees in many international conventions to which Canada is a signatory, as well as the European Convention on Human Rights. And the tortured interpretation of Section 28's equal rights guarantee as being essentially meaningless is based on a supposition that rights no longer exist when Section 33 is invoked. So if the rights no longer exist, there's nothing left to equalize, and so Section 28 is meaningless. But as the Saskatchewan Court of Appeal said recently, the Charter is not written with disappearing ink. All Section 33 does, and what its text says, is that laws can continue to operate despite these rights. It removes the remedy of invalidation. It doesn't remove the rights itself. And again, Section 33 has a limited scope, and one limit is right in the text, where it intrudes on equal rights. So limits on Section 33 aren't this kind of tricky end run. They're the Charter architecture doing its job. So the last myth I wanted to talk to you about is that parliamentary supremacy is fundamental to our constitutional order, but women's rights, not so much. So how it's presented, Section 33 is the linchpin of the 1981 deal. It's a pillar of federalism. It's the most distinctive feature of the Charter. The corollary is things like Section 28 are nice to have, but they're not what holds the edifice up. It's marginal, it's interpreted. Why this is a gendered myth? It elevates what men fought for in formal federal and provincial conferences, public power, while sidelining what women fought for in the margin and the back channels, equal rights. So those of you that have looked at some feminist theory, you can see how this reproduces dichotomies like the public-private, justice, equity, competition cares, and these dichotomies reproduce sexual hierarchy. And so what is the real story behind this myth? Well, the Charter settlement had multiple critical elements and pivotal moments. And yes, the Kitchen Accord and Section 33 was one of them. But there's another that defines, or is the commitment that defines Canada's political community, and that's sex equality that's guaranteed, notwithstanding anything. And if you look at how fundamental the notwithstanding clause is, really its use has been clustered around a few provinces, and of late, it's been aimed at vulnerable groups. And this is a break from even pre-charter constitutionalism, wherein the Supreme Court of Canada used the division of powers to say to provinces, no, you cannot target your political adversaries and religious minorities. So if Section 33 is a linchpin, it's really one that's letting the wheels slip off. Treating Section 28 as merely interpretive doesn't really give it a lot of work to do, and courts reject that for statutes, much less for the constitutional text. And in reality, Section 28 has infused the Charter with an equal rights ethos. And for instance, it's been credited with influencing our strong protections for reproductive freedom under the 1988 Morgentaler decision, under the rights of personal security and liberty. And so women's equal rights has made an outsized contribution to Canadian identity. And it's really stark, especially when you consider what's happening to our neighbors to the south, right? So if Section 33 is meant to be the safety valve, Section 28 is meant to be the guardrail. It's the part that tells us that the override power stops when it threatens the equal enjoyment of rights. And the issue is not that Section 28 is complicated. It's whether we're willing to take its words seriously. So I'm going to get into a little bit about the structure on how this all works in a real case. And scholars sometimes describe Section 28 in 3 different ways: that it has an interpretive function, that it contains an interdependent right, or it's a limit on charter limits. So things that are shields that protect laws from challenge under the charter. That's a charter limit. So the first function really doesn't add a lot beyond what the Section 15 general equality rights do. And the section really isn't central as far as the notwithstanding clause. So what I really want to focus on is the third function and the real power that matters for this conversation, that Section 28 operates as a guardrail, preventing other charter provisions, including Section 33, from being able to deny equal rights. And not only does this bar a government from doing this directly, from putting a clause in a law that says that it continues to operate notwithstanding women's rights, but as a matter of constitutional interpretation, governments are not allowed to achieve an illicit goal indirectly either. So you as a legislator cannot put a notwithstanding clause in a law that is neutral, one that says nothing about men or women, but has a disproportionate impact on women's rights. So I'm going to introduce you to a little hypothetical, and you can tell I've been inspired a little bit about what's going on in the United States, but I'm from here too, So let me show you how Section 28 works as a guardrail involving a hypothetical that has a notwithstanding clause that's neutral, but has a disproportionate impact. So let's say that Saskatchewan gets really concerned about its declining birth rate. It's concerned about rural depopulation. So one thing it decides to do is that it passes a law that restricts access to the birth control pill. And it invokes the Section 33 notwithstanding clause to shield it. Can it do that? Well, the law doesn't say anything directly about women, right? But look at the rights that are at play here. The right to liberty, probably security of the person, as the Supreme Court has described it, equality. But these are all rights that are covered by the notwithstanding clause. So absent a limit to the limit, yes, they can do it. And notice who is bearing the brunt of this collective goal here. It's women alone. So this was exactly the scenario that Section 28 was written for, to stop majoritarian politics from sacrificing women's rights and calling it democracy. So let's go through the framework and see how it would apply. So this is a framework, and again, I'm not making this stuff up. This is based on the Supreme Court of Canada's 2024 decision in Dixon, where it talks about another shield, which was Section 25. So that's the shield that shields the laws of Indigenous governments from charter challenge. So, and there it said that Section 28, equal rights, acts as a limit to that shield. So no matter what Indigenous governments do, they cannot shield gender-based discrimination. So I say that what's good for one shield should be good for another shield, right? The notwithstanding clause. So based on the framework that the court used there, here's the framework that me and a former student came up with in our recent paper. So the first thing you look at is Section 33 validly invoked? It's not a hard test. It's not a hard threshold from the Ford decision. Second thing you look at is this a right that's referred to in the charter? So again, not a high bar to meet. Is it referred to the charter or not? The real nub comes into the step 3. And would Section 33 otherwise shelter inequality in the enjoyment of rights between, in Section 28's words, male and female persons? If it is, then you strike down part of the law. So you could strike down part of the law that contains the notwithstanding clause and limit it to say that it doesn't apply insofar as it shelters unequal rights. So let's go back to my little birth control hypothetical. And we'll assume that the override is formally valid because it's a low bar. You have to say in the law what rights you're overriding. The right to equality, liberty, and security of the person, all clearly engaged, but the effect is unequal. The law doesn't say that it applies, it's overriding the rights of women, but it's women that bear the burden. And again, this is exactly what Section 28 says, is notwithstanding the override, the rights must be guaranteed equally. So in my Saskatchewan hypothetical, the remedy would be to limit the reach of the notwithstanding clause so it can't shelter that inequality. So let's jump now from the hypothetical to the real. Let's talk about Bill 21. And this is something that the Supreme Court of Canada is going to hear in an appeal from the Quebec Court of Appeal, probably late fall or early in the new year. So Bill 21, it has a notwithstanding clause. I think it's clause 6. And it seems to be valid. And again, it's not a high bar. What rights are referred to here? You could say not only freedom of religion. Obviously, if you're going to ban religious symbols, that seems like a no-brainer. It's going to implicate Section 2A, probably also women's equality under Section 15. Doesn't involve equal rights. Well, you could say, well, it's just talking about religious symbols. There's men that wear religious symbols. Sikh men wear a turban. Jewish men wear a kippah. But the trial judge in Quebec said that, be that as it may, the facts show that all or nearly all of the people that are affected were Muslim women that wore the hijab. And they were teachers mostly, as a matter of fact. And so these are women that could not receive promotions, and they couldn't even take the jobs that they were trained for because they wore the hijab. And indeed, it's probably no coincidence because when Quebec ministers talked about the law, they talked about targeting the hijab. So under step 3 of my little step analysis, you'd observe that these women are disproportionately impacted in their ability to practice the religion. So they are unequally able to access their freedoms. And again, Section 28 acts as a guardrail. It prevents the override from erasing equality in the enjoyment of charter rights. So what has to happen for step 4 is that you limit the scope of the notwithstanding clause. Probably you limit the scope of it by saying that it doesn't apply to the religious symbols ban in the law. So that leads us to our conclusion here. Let's think about where this leaves us. So in a recent work of mine, it's called A Law in Rupture, I talk about Bill 21 specifically and how it represents a rupture in the fabric of charter rights as rights that have a blanket over the entire country. But there's similar ruptures that are happening across the country in different ways, between regions, between people, between and involving trust for organizations like courts, like elected representatives. And times like this, we have to remember that democracy is fragile. And it requires other ingredients to really hold together. Respect for minorities, the rule of law, and one of these other ingredients is constitutionalism. So the notwithstanding clause can be a democratic safety valve, certainly. There's times that judges might get it wrong. There's other values that might need attending to. For instance, Alan Blakeney had a great point, and he said there's no specific reference in the Charter to having a right to be free from want, a right to be free from poverty, from hunger. But it only operates that way when there are basic guardrails that stop the notwithstanding clause from veering off course. Otherwise, it becomes the way for the biggest and the most powerful to have their way. And Section 28 is one of those fundamental guides. And the student that I co-wrote this recent paper said, it dictates the safe channels in which all constitutional powers, including Section 33, must navigate. So I'm going to close now with a bit of a provocation. If Section 28, written in the clearest language, notwithstanding anything, cannot guide the notwithstanding clause, then what does constitutionalism really mean? It must mean more than a male fantasy of sexual equality. It must mean genuinely equal rights for everyone. Thank you.
We have a chance if people have a few questions that they want to put forward to Professor Clark.
Yes, Mom.
I was very relieved to hear that that Section 28 acts as a guardrail in many instances. But then I took a look at Margaret Atwood's White Hoods, and I thought to myself, oh dear, what would happen if in the future, such as is happening in the US right now, what would happen to transgender peoples? Would they be protected under Section 28 or not?
That's a good question, and it's one that's come up a number of times. With respect to the recent litigation that's going on with the Saskatchewan Parents' Bill of Rights, they haven't pled Section 28, probably because it's pretty much an undiscovered country at this point. The English Montreal School Board case concerning Bill 21 is going to be probably the case that really puts some meat on the bones of Section 28. Want to get that? So it really depends on the context of it. What I would say is that Section 28 is fundamentally about gender hierarchy. It's about devaluing femininity and upholding masculinity and these traits. So if you had a claim involving trans individuals, trans students, whatever, that it might be called upon to protect trans individuals. So it's kind of a lawyer's answer to say it depends, but it really does depend a lot on the context. And as I like to say, Section 28 can't do everything. Women tried to get Section 15 out of the grasp of the notwithstanding clause. They tried very hard, but were unsuccessful. So 28 is what we have. And potentially in some context it could be used in relation to trans rights. But again, it really depends on if the case is bringing forth that idea of sexual hierarchy or not. Other questions?
We have a question in the back, and if anyone wants to make their way to that microphone, please do, or we can also try to move this one around. But go ahead.
Thank you so much for presenting today. I'm a fourth-year student in a social justice studies degree, and so this feminist analysis is just incredible. That was kind of my question, starting off with how we understand this in the context of Bill 137 when we're not dealing with a binarized gender discussion. But I'll maybe push just a little bit further in asking, do you ever think that if we were discussing this matter within the relation of just trans women, that could be called on or then further potentially discriminate when we're looking at the nuances of a spectrum of transgender identity or gender nonconforming folks? So I guess maybe just kind of adding off to what you already said, but I appreciate you touching on that question already.
Right. So, you know, at the time of Section 28, we didn't really have that kind of concept of kind of a gradation of gender identity. But I think even so, you know, what it says is male and female persons, which to me says biological sex. Everyone has a biological sex, but what that means is 28 is there for everyone. And so the fact that it refers to male and female persons, I don't think necessarily excludes, you know, claims that are made for trans rights and in relation to trans women. But again, it really depends. Some people have argued that, well, using living tree constitutionalism, you can grow and evolve the concepts of male and female persons. And that's what the Supreme Court of Canada has said before, is as society evolves, so does the meaning of constitutional terms. So as it stands now. But even, you know, I've said in other work that I kind of cast a side eye to Living Tree because it really hasn't helped women that much. But what I can say is when you look at the development of 28, it was really about genuine equality so that people's rights are not devalued on the basis of their association with a feminine identity, right? So, like I say, I don't think we're there yet. I'm anxiously hoping that we'll get some more real Section 28 doctrine from the Supreme Court of Canada, and then we can go with that. We can see what possibilities are out there for it. But those possibilities aren't foreclosed. We'll have to see.
We, of course, welcome students to Rosebery University, and it's great to have you here asking questions. Does any law student want to ask a question so you're not outdone by other parts of the university?
Hi, Professor Brock.
Nice to see some students from my first year con law class here.
Yeah, kind of speaking to that topic, Olivia and I are here with Women in Law today, and we're trying to, you know, advocate for discussions kind of centered around these topics. And I'm just wondering, I would love to hear your opinion on how this specific topic or topics related to Section 28 could be more productively integrated into our JD degree. Whether you see that in a first year class or in an upper year class, or just, do you see that potential there, and if so, how?
Yeah, well, I always try to sneak it in, and as a matter of fact, the student, or the paper I recently co-wrote with another student is something that came out of my advanced constitutional law class. He actually wrote a paper, and I said, hey, you have some cool ideas, want to write a paper? So it's really going to be, I think, to a great extent up to your generation to carry the ball and really make these arguments practical and realizable by a court. Jack Balkin, who is an American theorist, but I really like him, what he says is that there are off-the-wall constitutional arguments and on-the-wall. But as society evolves, and civil society starts engaging with the idea of interpreting rights, something that seemed once off the wall as far as constitutional argumentation becomes on the wall. So a really good example of that is in relation to same-sex marriage. We had some early cases by lower courts to say that you know, the common law requirement that marriage is between a man and woman to the exclusion of all others. It has to be a heterosexual union. You know, how the courts in Ontario interpreted that to say, well, gays and lesbians can marry. There's no discrimination against them. They just have to marry someone of an opposite sex. So that, at the time, was seen as this is the reasonable and rational constitutional interpretation. Now go to the same-sex marriage reference by the Supreme Court of Canada and the Halpern case. And those cases, you can see that it almost seems absurd, those kinds of arguments. And indeed, I heard some laughs. It's absurd to us today, right? And that's a really good example of how off the wall becomes on the wall. How we think of common sense argumentation really changes how society changes. So, you know, that's a long-winded way of saying I try to sneak it in to some things in constitutional law, but, you know, really I think we'll need some more jurisprudence for it to become part of the constitutional canon and for people to take it seriously. So thank you for that.
Time for one more question, and I know students have class at 1, go late, but we'll have one more question.
Do you think Section 28 analysis will kind of suffer from the same problem as the court trying to really flesh out what is a substantive right, either impaired or not, as they did in Section 15 cases?
Yeah, that's, you know, and indeed, when Section 28 first had some initial analyses by the court, it was horrible, it was terrible. What the court said is that, well, what Section 28 really does is it forbids any distinctions in the law between male and female persons, between men and women. So the initial litigants for Section 28 almost exclusively were men. And they weren't about getting more rights for men, but they were about attacking rights for women in the law. So for instance, in Nova Scotia, there was like this teeny weeny little supplement that single moms got to recognize the fact that they were poor. And that was struck down in part on the basis of Section 28. So what my personal opinion is, you can't just operate in the legal frame. What you have to do is operate in the public frame and really change civil society so that, like with same-sex marriage, something, you know, it seems absurd that we would not protect equal rights. So it's really, I think, a strategy for you as young lawyers. Sometimes you can't just fight in the courts, and you can't write like super great legal arguments. As you'll find out, sometimes the really tight legal arguments are the ones that are gonna fail, and they have failed for me many times. So what you have to do is you all have to be good constitutional ambassadors. So you have to go out, talk to your friends, talk in public, write op-eds. I know that seems really scary, but you can do it, and newspapers love to hear from young people. So go and do that. And also write the good legal arguments, because like you say, there's that danger that courts, being rather conservative, will have really bad interpretations of Section 28. And I guess we'll see in a few months whether what I've been working on for the last 20 years is completely in vain, and I'll go and scuttle under a rock and try to figure out something else. But hopefully that won't be the case. So thank you for that.
Okay, on that very practical note of things that you student come forward and offer formal thanks to Professor Frock. Just as that's occurring, I want to extend our thanks also to Katie Richard, the staff member at the College of Law who assists the Speakers Committee and runs events like this. Thank you to all of you for being here. Okay, and so that's been presented already. So thank you to all of you for being here. And I'll just say, if you still want to learn more, Professor Frock's here, and she's at the college in the coming while, and her conference is coming up, so make use of those opportunities as well. But please join me in thanking once again Professor Frock for a fantastic lecture.